Hello and welcome back to In Your Defense. I'm attorney Steve Toland. Today we're going to finalize our series on alcohol and boating, or boating while intoxicated investigations. It's been a very interesting series. I hope you've enjoyed it. Today let's talk a little bit about the worst case scenario, which is a conviction, and what the penalty ranges are for boating while intoxicated. These are very similar to a DWI, or driving while intoxicated. So a first offense and conviction for BWI is a Class B misdemeanor as long as your blood alcohol level is under 0.15. In that case, like all Class B misdemeanors in Texas, you face up to a $2,000 fine and up to 2 years of probation, or a 3 days in jail, sentence. On a Class A misdemeanor, which would be 0.15 or higher on a first-time conviction for BWI, or a second conviction, which seems highly unlikely ever to happen to a person, but nonetheless, if it did, and your blood alcohol level, if it's a second offense, or your blood alcohol level is over 0.15, that's a Class A misdemeanor. Like all Class A misdemeanors in Texas, punishable up to a $4,000 fine, same amount of probation, up to 2-year probation, and jail sentence substantially similar to that. What can happen in a BWI case, though, which is tragic, is that a lot of times it's an accident that brings law enforcement onto the scene, and then a subsequent arrest is made for BWI. So if somebody's injured, suffers serious bodily injury, that's a third-degree felony in Texas. That's punishable from 2 to 10 years in prison, up to a $10,000 fine, or up to 10 years of probation. Also, God forbid, if somebody is killed and you are convicted of BWI, that is manslaughter in Texas. That's a second-degree felony, and that's punishable from 2 years up to 20 years in prison, or a $10,000 fine, as well as the possibility instead of doing up to 10 years of probation. So those are your penalty ranges. In addition, a lot of people are surprised to learn that a conviction for BWI is exactly the same as a DWI in terms of your driver's license suspension. So you can have a suspension for up to 90 days or more, depending on the number of convictions you have. So it can affect you in a lot of ways. A subsequent offense for BWI or a felony for BWI can also trigger the judge to ask or order you to install an ignition interlock device in your motor vehicle, even though you were driving a boat for your conviction. So all those things can come into play. That being said, these are very defensible. We've talked in past episodes about the importance of hiring an attorney immediately and vigorously attacking these cases. They actually use what are called seated flotation sobriety exercises, SFSTs. And those are literally where you sit down and they check you. And we talked about how the signs of being on a boat for an extended period of time are very similar to the signs of intoxication or impairment that somebody could have. So because there is a 32 or 34%, depending on the literature that you read, false arrest rate for those field sobriety tests that are actually called seated flotation sobriety tests. And because the signs of impairment can be the same as signs of just people being on a boat not being impaired, that's why you need to vigorously attack these. So you need to hire a really good attorney. We have tons of experience in this area. So I hope you've enjoyed our 3-part series on alcohol and boating. I hope it's been informative to you. And as always, if you or a loved one face any type of issues with this, or have been arrested and charged with BWI, reach out to me right away, attorney Steve Toland, or us here at Peak & Toland. Thank you.